Hi, I'm Benjamin Payne. At the K-12 Education Office at Hillsdale College, we support school founding groups and their efforts to start classical schools across the country. Finding the right leader is one of the first and most important steps to building a successful school. While we do consider experience in education, we seek candidates who exhibit unwavering personal integrity, honesty, courage, and servant-hearted leadership. Perhaps that's you. If you're looking to engage in fulfilling, impactful, and challenging work protecting our nation's future and building up the next generation of virtuous citizens, we'd love to hear from you. I'm looking for strong school leaders right now. Learn more about how you can make a difference at hillsdale.edu/leader. hillsdale.edu/LEADER. That's hillsdale.edu/leader.
Welcome to the Hillsdale College K-12 Classical Education Podcast, bringing you insight into classical education and its unique emphasis on human virtue and moral character, responsible citizenship, content-rich curricula, and teacher-led classrooms. Now your host, Scott Bertram.
We continue a series of episodes from presentations delivered at Hoogland Center for Teacher Excellence seminars. The Hoogland Center for Teacher Excellence, an outreach of the Hillsdale College K-12 Education Office, offers educators the opportunity to deepen their content knowledge and refine their skills in the classroom. These one-day conferences are hosted during the academic year in cities across the nation and feature presentations by Hillsdale College faculty, K-12 office staff, and leaders in the Hillsdale network of member schools. There is no cost to attend, and attendees may earn professional development credits. Currently, the Hoogland Center is hosting a series exploring the art of teaching a variety of subjects. To learn more about upcoming events, visit our website, k12.hillsdale.edu.
Good morning, everyone. Great to meet you all. Again, on my pocket copy of the Declaration of Independence and the Constitution, which will be our principal primary source for today. I'm supposed to talk about the enduring principles of the American founding, and I'm going to talk about them principally as they are embodied in the Constitution. As Eric mentioned, that's the theme of Dr. Arndt's book, The Founder's Key. I want to start talking first about what are the sort of the eternal, timeless political theory behind the American founding, and then how the Constitution in particular tries to realize or instantiate those principles. And they're very easy to find if you just go to the first page of the Declaration of Independence. The second paragraph, Jefferson's famous sort of epitomization of John Locke. And John Locke is certainly the most important political theorist who's behind the founding generation. That we hold these truths to be self-evident. In other words, that there are certain eternal, unchangeable philosophical principles behind all governments, that all men are created equal. Almost all of American history is sort of a working out of what the meaning of that term equality means. That they're endowed by their creator with certain inalienable rights. That idea that rights don't come from government, they precede government, that they come from our creator, nature and nature's God. That to secure these rights, governments are instituted among men. Right there in a nutshell, and Jefferson was very good at putting things concisely, briefly, that the purpose of government is to protect pre-existing natural rights. To secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, right? The basic social contract theory of consent that's behind Locke and a lot of the other sort of 17th, 18th century social contract theorists. And Jefferson goes on to talk about the right to revolution. That's exactly what's going on in the Declaration of Independence. And the Constitution, in a way, is certainly altering or abolishing a previous form of government under the Articles of Confederation. So you have the basic political theory of the Declaration of Independence expressing what the American founders thought government was about, right? What was its end? What was its purpose? What is government for? Locke and the Declaration of Independence doesn't have a lot to say about the particulars. It's true that if you read the body of the Declaration of Independence, it does mention some particular institutions. The trial by jury, vice admiralty courts, and things like that. But it doesn't say anything about the structure of government, what kind of government is necessary to achieve the ends that are articulated in the second paragraph. As I often tell my students, there's nothing incompatible between the Declaration of Independence and a monarchy, right? The Declaration isn't rebelling against monarchy per se. It's rebelling against George III, who was a tyrant, right? Which is a bad monarch, right? Now, as it turns out, the American founders went almost immediately to a republican form of government rather than a monarchical one. But those are the kinds of options that you still have under the political theory of the Declaration of Independence. As long as it was a monarchy that was based upon popular consent, it would be okay, right? Locke did have some things to say, though, about the particulars of government in the second treatise, where he talks about some of the basic principles of constitutionalism. What are the limits that have to be built into any kind of government to be legitimate? And he says, these are the bounds which the trust that is put in them by the society and the law of God and nature have set to the legislative power of every commonwealth in all forms of government. Again, these are timeless, eternal. They don't depend upon time, place, and circumstance. First, the people, are to govern, the legislature is to govern by promulgated and established laws, not to be varied in particular cases, but to have one rule for rich and poor, for the favorite at court, and for the countryman at plow. The equal protection of the laws. The laws need to be general and prospective. Secondly, that these laws also ought to be designated for no other end ultimately than for the good of the people, the public good. Another essential limit on government is law, to be legitimate, has to be for a public purpose, not to serve some private interest. Thirdly, they must not raise taxes on the property of the people without the consent of the people, given by themselves or their deputies. And this property concerns only such governments where the legislature is always in being, or at least where the people have not reserved any part of the legislative to deputies to be from time to time chosen by themselves. Locke here is talking about you could have a society where every citizen was a legislator, right? Ancient Athens was like that. Rome originally was like that. Now, again, in America, we're going to see that representation is one of the fundamental principles of American constitutionalism, but for Locke, it's an optional one. Fourthly, the legislative can neither must nor can transfer the power of making laws to anybody else or place it anywhere but where the people have. You'll be hearing a lot in the forthcoming years about the delegation of legislative power, the non-delegation doctrine. And we'll talk in a few minutes about what the Constitution has to say about that. So anyway, Locke does have some things to say about what the limits on the legislative power, the sovereign power of government are. And you can see these in the Constitution. If you just go to the very beginning of the Constitution, this is on page 8 of your pocket Constitution. The first three words of the preamble, we the people, right? This is an expression of the Lockean principle, the Jeffersonian principle of consent. Popular sovereignty, and it's not to be confused with that term which is often used in the discussion about slavery in the territories before the Civil War, right? In a way, Stephen Douglas there was sort of abusing that term, popular sovereignty. I'm using it in the sense of the Lockean principle that all government power, legitimate government power, derives from the consent of the people. So in some ways, the most important, the cornerstone of the Constitution is the beginning of the preamble, that principle of we the people. But in what follows, the important thing is that the people express that consent always through representatives, right? There's no way under the U.S. Constitution that the American people ever act en masse, right? States, I don't know if Florida has, but I know Michigan does, and a lot of others do. They have referendums and citizens' ability to initiate legislation outside of the legislature, right? We'll talk about this this afternoon. Those were progressive reforms that were meant to deal with what the progressives thought were shortcomings in the American Constitution. But the founders, when they established the U.S. Constitution, and Madison makes this very clear in Federalist 63, he says, yes, the American people are sovereign, but they never actually operate the government themselves. They always do it indirectly through representatives. A lot of other countries in the world have popular referenda, like the British, right? They just voted for Brexit in a nationwide referendum. But in the United States, to this day, we still have no means of doing that, and there's nothing in the Constitution that permits that kind of direct democracy, as the progressives call it. In fact, many people argued in the 20th century that those state referenda that provided for direct popular government like that were unconstitutional. right? One of the provisions of the Constitution says the United States shall guarantee to every state a republican form of government. And Madison said Republican government means through representatives, right? The majority doesn't govern directly. They do so through the diffusion, the refining and the enlargement of views that come about through representation. So on the one hand, popular sovereignty, but according to the American Constitution, popular sovereignty is exercised in a peculiar indirect way, right? Now, that's a controversial point, and if you were critical of founders, you would say, yeah, that's the way that the founders are really neutralizing and preventing democracy, right? They start by saying we the people and all this talk about popular consent, but then they make it impossible for the people to rule. Again, this afternoon, that's what the progressives are going to say. But I'll leave that point for further debate later on. So popular sovereignty is number one. The number two, I think the most important principle that you find in the Constitution is that of federalism, that this is a divided government where neither the national government nor the states are sovereign. Madison talks about this, especially in Federalist 39, where he says that maybe the most unique contribution that the Americans have made to politics is this idea of a compound republic, being neither completely federal nor completely national. Neither the states nor the government are sovereign. Now, on the one hand, and a historian should be the first one to point this out, he would say that this really isn't a political principle so much as it was a practical necessity. That at the Constitutional Convention, you couldn't have had a constitution unless you had what's known as the Great Compromise, right? The Connecticut Compromise, where you have one part of the government representing the states as states and another part representing the people directly through the House of Representatives. And there's a lot of truth to that. That was a peculiar situation in the 1780s that had to be dealt with, and that's why it was the Great Compromise. On the other hand, federalism does have some value inherently as a political principle. In Catholic social theory, it's known as subsidiarity, the idea that problems should be dealt with as close to the people who affect them as possible, that at a certain point, government becomes too out of touch with the people that it's serving for it to serve them well. A lot of the anti-federalists made this point in their opposition to the Constitution, that a representative who represents, and back then it would have been 30,000 people, I remember the House of Representatives, is going to be too distant from the people to really serve them. Today, a representative represents about 800,000 people in the United States. Most state legislators represent more people than congressmen did at the time of the American founding, right? And Madison, when he says, well, there are benefits to what he calls the extended republic, there are also certain limits to it. At a certain point, government does become too distant from the people. So it's worth considering today whether we've reached that point or not. You can see this, too, in the Constitution, this principle of federalism expressed. It's there when we talk about the two houses of Congress, especially in Article 1. It's also in the 10th Amendment. And if you look at the 10th Amendment, this is an expression of the principle of federalism. In fact, Thomas Jefferson said the 10th Amendment really is the most fundamental point in the Constitution. The path is on page 30. The power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Right? Now, you could say, well, the 10th Amendment wasn't part of the original Constitution. It's an amendment. I would argue otherwise and say that really almost none of the Bill of Rights really changed anything in the original Constitution. James Madison, who was the one who oversaw the drafting and the sending out of the Bill of Rights to the states, wanted to make sure that the Bill of Rights didn't change anything, or at least didn't change anything really important about the Constitution. So to say that the 10th Amendment is really redundant, that it's simply making explicit what is implicit in the structure of the Constitution, is the argument that I would make. But it's a very, I think, handy way to express that point. The 10th Amendment also is protecting what comes to be called the police power of the states. Because if you read what the 10th Amendment says, basically it's saying that if the Constitution doesn't grant the power to Congress, we assume that Congress doesn't have it. But if it doesn't forbid the power to the states, we assume that the states do have it, right? And that's known as the police power, the general power that the states have to legislate for the safety, health, welfare, and morals of the people. It's a really fundamental principle in American constitutional law well into the 20th century. And well into the 20th century, the states did take care of most of the purposes and questions of government. The federal government really was limited to mostly foreign policy questions and sort of interstate questions. So the original Constitution was meant to preserve the police power of the states and to make sure that Congress didn't impinge upon those. Another reason why federalism, I would say, is the most important principle of the Constitution is you can see it in every article of the Constitution. It's built into every part of the Constitution. Article 1, obviously, right, the bicameralism of having a House and a Senate is the great, sort of Federalist principle. That's, again, the great compromise at the Constitutional Convention. Article 2 of the Constitution, the president being chosen by the Electoral College, right, rather than a simple popular majority. People tend to forget this, but now it's happening frequently enough that people should understand by now that the president is not chosen by a popular vote of the entire nation, that it's the Electoral College where the states have different weighted powers. Some states benefit from the Electoral College system and some states lose influence in choosing the president. California clearly loses, Wyoming gains, right? More states gain than lose, and that's why we're going to be stuck with the Electoral College forever, right? As a practical matter, right? But the idea that the president is going to be chosen by a federal system, by the states as much as by the people, especially when you go back to the founding generation, the Constitutional Convention, they expected that after George Washington, right, very few people are going to have the kind of stature that could allow them to attain a majority of the Electoral College. And what happens when the Electoral College fails to produce a majority? Congress, the House of Representatives, chooses the president, and they do it in a very peculiar way. Each state gets one vote, right? There's a delegation. 55 members of California get one vote, and the one representative of Delaware gets one vote. And that's how they expected the president would normally be chosen. That's a very federal, very state-based basis for the presidency. Now, it didn't work out that way. Very quickly, the party system formed, and almost always you were able to translate a national popular majority into an Electoral College majority, but that was kind of something the founders didn't anticipate, the development of the parties. So Article 2, very federal. Article 3, you might not see it on its face, right? The judicial, the judges, the federal court system. But the judges are confirmed by the Senate. One of the important parts of the checks and balances provisions of the Constitution was the president shares the appointing power with the Senate. And again, the Senate represents states as states. In the old days, there was kind of an unwritten rule that Supreme Court justices would represent different parts of the country, right? Even if all the best judges and lawyers were in Massachusetts, you can't have all the Supreme Court justices from Massachusetts. The South has to have one, the West has to have one, right? We don't do this anymore. Now it's more based upon sort of ethnic, religious identity, sex, things like that. But at the time, there was kind of an understanding that each part of the country would be represented on the Supreme Court. So even Article 3 has a federal element. Article 4, the so-called Comity Clause, is all about federalism. It's about what the states owe to one another, right? Interstate relations. Again, what the states have to do in terms of returning fugitive slaves and things like that. So Article 4 is all about what the states have to do. The full faith and credit clause, right? If you have a driving license age in one state, does another state have to honor that? We went through this before the Supreme Court sort of made it a national issue, whether states without same-sex marriage had to represent states that did have it, things like that. That's Article 4 stuff. Right? Article 5, amending the Constitution, you can't do it without the states, right? Congress can either initiate the amendment process itself, or the states can, right? If 2/3 of the states demand it, Congress has to call a constitutional convention. That's never happened, but we've come pretty close. Often Congress has acted in response to the threat of a state-initiated constitutional convention. Right? And if you want to ratify anything that Congress or a convention proposes, it has to be done by the states. Either the legislatures or popular conventions, but 3/4 of the states as states have to ratify constitutional amendments. Right? So again, every part of the Constitution has some federal element in it. I think it is the most significant, pervasive feature of the Constitution. Okay, the next one would be the separation of powers or checks and balances. And in a way, those two terms are often conflated, but in fact, they were in some degree in tension with one another. And really what was happening at the Constitutional Convention was the founders were reacting to the fact that the state constitutions had too much separation of powers. And the practical experience of state governments in the 70s and 80s was the legislative branch took over everything. Right? The executives and the judiciary were too weak, and you had what was often referred to as legislative tyranny or majority tyranny. So a lot of what the founders tried to do in strengthening the presidency and the judiciary was to counter what they had seen in the states. States were passing bad legislation, unjust legislation, legislation of the kind that would violate Locke's principles of the limitations on the legislative power. Some of these you can see in particular in Article 1, Section 10 of the Constitution, those specific prohibitions on the states. And the one that really stands out was no state can make anything but gold or silver coin legal tender in the payment of debts. Because a lot of states were doing that in the 70s and 80s. They were passing paper money laws, which are basically inflationary laws or debtor relief laws that the Federalists were very much opposed to. Right? So the principle of the Constitution is we contain what in Republican governments, the legislative branch is always going to be the most powerful because it's closest to the people. So in order to keep it from getting too powerful, we institute checks and balances from the other branches, right? Especially the particular powers that are given to the president, things like the veto, or at least the conditional veto, the power of appointment, although that's shared with the Senate, the president's pardon power, right? All those particular prerogatives that the president has are part of the founders, saying we want a stronger executive. Often, people today talking about defending executive power would say, notice that the language of Article 2, we'll talk about this a little more in a little bit, provides for a unitary executive. I mean, just the fact that the founders established one person as a president. You had nothing like that under the Articles of Confederation. You had sort of a committee of the Continental Congress that served as an executive branch. Likewise, in the more radical state constitutions like Pennsylvania. But here we have a strengthened a presidency and a strengthened judiciary. And the judiciary one is especially important. I'll talk about that in a moment. Okay, now if we go to the particular parts of those branches, the very fact that the Constitution has in Article 1, Article 2, and Article 3, three distinct branches of government. And you'll notice, too, the Constitution never uses the term separation of powers. Some of the state constitutions did. They would say in tedious detail, the legislature shall never exercise executive or judicial power. The executive shall never exercise legislative or judicial. There's nothing like that in the Constitution, right? It was sort of a step away from the strict separation of powers towards this new thing of checks and balances. And again, the Publius, the Federalist Papers, had to do a lot of defending of the new Constitution against anti-Federalists who claim it's violating the sacred principle of the separation of powers. Anyway, Article 1 is on page 8 of your Constitution. Every part of the three parts of the Constitution that establish the three branches all start with what is known as the vesting clause. And Article 1 begins with, all legislative powers herein granted shall be vested in a Congress of the United States. Right? And again, it's easy to look at the Constitution if you're familiar with it and overlook the significance of what appears to be just sort of matter-of-fact, sort of blasé statements of what we all know. But there's actually a lot of significance packed into these seemingly, superficially insignificant words. And Article 1 starts out by saying all legislative powers herein granted are vested in the Congress of the United States. It doesn't say all legislative powers are granted to the Congress. It says only those that are herein granted. This principle is known as that of the enumeration of legislative powers. This is maybe the most important limitation upon congressional power, the fact that its powers are specified or enumerated in what follows, mostly in Article 1, Section 8. Coin money, raise and support armies, commerce among the states especially. But that Congress is limited to its enumerated powers is the most important limitation on the legislative branch. And again, Congress escapes a lot of this in the 20th century. I'll talk about this more this afternoon, mostly by just saying everything is commerce, and so we can regulate everything under the sun. There are some limits on that the court has upheld recently, but pretty much almost all of Congress's power derives from a broad definition of commerce among the states. So all legislative powers herein granted shall be vested in a Congress of the United States, right? There is what's known as the non-delegation doctrine, that the sovereign people have given to Congress certain particular powers, and they have given to Congress no power to delegate those to anybody else. Right? This is probably the greatest problem in the creation of the bureaucratic state or the administrative state that I'll talk about this afternoon. The problem is that agencies like the Federal Trade Commission or the Fed or the National Labor Relations Board are actually making laws. They are exercising legislative powers because Congress, in the legislation that created those agencies, basically gave those agencies the power to say what the law is. And that is a violation of the language of the Constitution here, that the power is vested in Congress. It doesn't say it's vested in Congress and whoever Congress chooses to give the power to. And again, if you go back and read John Locke's second treatise, he's very explicit about what the basis in political theory for the non-delegation doctrine is. The people are sovereign, and they delegate certain powers to the legislature and do not give the legislature the power to subdelegate those to others because they come from the sovereign people. Right? So right in the first sentence of Article 1, Section 1, you have an important sort of description of what the limits of the legislative power are. Likewise, in Article 2, the vesting clause of the executive branch, the executive power shall be vested in the President of the United States of America. Right? And when I do this with my students, I often ask them, what's the most important word in that sentence? Right? And they'll pick power or executive or whatever. I say, no, the most important word in that sentence is right? That it is a single person, the unitary executive, right? That we don't have a plural executive, we have one person, right? This is the most important thing that makes the legislative power of the presidency a stronger one, way too strong for the anti-federalists of the founding period, right? Alexander Hamilton especially, he was sort of the highest of the Federalists, the one who wanted the strongest national government. He really wanted a unitary state even more than a unitary executive. But he wanted what he referred to as energy in the executive. If you're going to have an effective government, even if it's a limited government, you want it to be effective and efficient, you need accountability, and that means you need one person to be responsible, right? If you want to hide responsibility, form a committee, right? If you want to delay something getting done, that's what committees are good for, and that's what Congress is good for, right? That's a deliberative body. If you want to get things done, right? If you want execution, give it to one person and hold that person accountable and responsible, right? So you have a unitary executive. One of the problems with the independent regulatory agencies that I've been discussing, the National Labor Relations Board or the Fed or whoever, is that the president is able to evade responsibility, right, by saying that these people are deciding what the law is, not me. I could give you a lot of particular examples of the way that recent presidents have done that, right? That's it. It's enabling them to escape political responsibility. The founders' whole idea was that people need one person that they can hold responsible for the execution of the laws, right? And the modern proliferation of executive agencies hides that. Notice also the vesting clause says the executive power, right? Article 1 says all legislative powers herein granted. Article 2 doesn't say all executive powers herein granted. It says the executive power, i.e., if a power is executive, it belongs to the president. You don't have to look for an enumeration of powers in Article 2. Now, I will admit, if you go on and read Article 2, it does mention some specific powers that the president has. Most of those are specifying powers that he shares with other parts of the government, mostly the Senate, right? In other words, or even more important than that, the power to declare war. That was considered an executive power under the British Constitution. The king alone could declare war and make treaties, right? But the president, Congress has complete control over the power to declare war, and his power to make treaties is shared with the Senate. So those you can say are exceptions to the executive power. But there are some others that seem to be executive powers that are articulated in Article 2, right? Like the power to ask the heads of departments to give their written opinions about certain questions, right? Well, that seems to be inherently executive power. Hamilton in the Federalist Papers says, yeah, that probably shouldn't be in the Constitution, right? So it is not quite as clear as the unitary executive theory makes it out to be, but looking at the text of Article 2, you could say it provides for certainly a strong executive compared to what we had under the Articles of Confederation and compared to what you had in most state governments. The U.S. Constitution president is stronger than any governor in this period, even states that had stronger governors like Massachusetts or New York. Right? Article 3 is perhaps the most interesting of all. The last book I wrote was about the Supreme Court. When you teach constitutional history, you tend to have to deal with the Supreme Court. In the 20th century, it takes over more and more of constitutional interpretation. And the very fact that you have an Article 3 was something innovative. In Locke's theory, we're used to this idea that there are three branches or three parts of government. For Locke, there were really only two. There was the legislative, actually, for Locke, there were three, but they're not the three that we are familiar with, right? Locke said there's the legislative power, there's the executive power, which is about enforcing the law at home, and then there's what Locke called the federative power, which is dealing with foreign affairs, making treaties, war and peace, that kind of stuff. The idea of a separate judiciary as a branch of government was really new. Montesquieu in the 1740s, when he writes The Spirit of the Laws, is the first one who comes up with this idea. The English courts had just established their independence at the end of the constitutional conflict of the 18th century, the Act of Settlement in 1701, I think it was. And some American states had also begun to establish separate judiciaries in their constitutions. But they weren't nearly as strong as the Article 3 judiciary that's established under the U.S. Constitution. This was, again, perhaps the most innovative thing of all, that never before had a judicial branch been so identifiably independent and had so many institutional protections. The most important one, of course, is life tenure. There's some argument among historians about whether the good behavior clause of Article 3 amounts to life tenure, but certainly it's largely understood that sort of way, right? Their salaries are protected. They can only be raised. They can't be lowered, right? They're not chosen by the people directly, like in many states. In fact, most states, judges are popularly elected. They're appointed by the president and only with the consent of the Senate. So they are very removed from the American people. And there's other parts of Article 3, too, that you could look at that would show you the strength and the breadth, or at least the potential strength and breadth of the federal judicial power. But this was certainly one of the checks and balances provisions of the Constitution that was most innovative. And if you're looking in the Constitution for where the federal courts acquire the power to establish their supremacy, that's in Article 6 of the Constitution, the so-called Supremacy Clause. Because it's true, if you look in Article 3 or any other part of the Constitution, you don't find any power of the Supreme Court to declare acts of Congress or even acts of the state legislatures unconstitutional until you get to Article 6, the Supremacy Clause. This is on page 25, the bottom paragraph. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges of every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding, right? So this idea that laws, the Constitution is the supreme law of the land, everyone understands that, right? But it says that laws made in pursuance of the Constitution are the supreme law of the land. That means there may be laws that are not in pursuance of the Constitution. They are not the supreme law of the land. And it seems to be the duty of the courts to say that such laws that are not made in pursuance of the Constitution are not constitutional, we would say. This is John Marshall in Marbury against Madison. I think it's pretty convincing, the argument that he made there, which was the same argument that Hamilton makes in Federalist 78, is correct, but it's not indisputable. And the language of the Constitution isn't crystal clear about what we call judicial review. But that certainly becomes the most important way that the court is able to assert its independence, or at least its equality with the other branches of the government. If you were to say to me the court's gone further than that and has established its supremacy, not only over the states, but over the other branches of the government, I would largely agree with you. But I would say that's not what the original intent of the framers of the Constitution was. So Article 3, separate judicial branch, is one of the most important innovations of the Constitution. One that I think today, if you were to ask the founders, if you were able to resurrect James Madison and say, well, what's most surprises you about the way that things have developed in the American Constitution? We're going to talk about this afternoon the establishment of the sort of bureaucratic state, the administrative state. think Madison would have said, that's not such a big surprise. We'd seen that before in world history. All of what I'm talking about today is really meant to prevent that from happening, but you can see the way that the Constitution was not administered in a way that prevented it from happening. But I think he would be most surprised by the power of the Supreme Court. That the United States was a leader in this. There are other countries today that have really strong judiciaries. In fact, before the whole Gaza stuff broke out, Israel was in this constitutional crisis about the strength of its own Supreme Court. The British were the opposite model, right? For them, really what the American Revolution was all about, Parliament is sovereign, or the king in Parliament. Yet Britain adopted a constitutional Supreme Court not that long ago, and they already started throwing their weight around with regard to Brexit and things like that. So there are countries all over the world now that have American-style judicial review and judicial supremacy. But America was the first one to adopt this, and I think the founders would have been most surprised about that. Hamilton, again, in Federalist 78 says, you don't have to worry about the power of this court, right? The judiciary will always be the least dangerous branch because Congress has the power of the purse and the executive has the power of the sword, but all that the courts have is the power of persuasion. And so they'll never become a political threat. But very interesting story is the way that the court it's established the kind of supremacy that it did. Okay, and Article 5 of the Constitution, the amendability part of it. This is really also indispensable. You could not have had you couldn't have had a constitution for a lot of reasons. If George Washington wasn't there along with it and presiding over it, and with everyone's assumption that he's going to be the first president, right? One of the ways the Federalists were able to sell some people thought dangerously strong, sort of the fetus of monarchy, as it was called. Article 2 of the Constitution was, don't worry, we all know who the first president's going to be, and it's George Washington, the man who embodies the kind of virtue that Republican governments need to succeed, right? You can also say if there are parts of the Constitution that you're not happy with, we can change it after ratification. So the fact that the Constitution was amendable was indispensable in making it, getting it ratified. And ratification itself was a close enough battle fought in the 1780s in the various states, ratifying the Constitution. And another important point about Article 5 was that by allowing a process of amendment, we're able to bring over some people who have their doubts about the new Constitution. Thomas Jefferson was a good example of this, right? He liked the Constitution. There were some things he didn't like about it. And he told friends in Virginia, make your ratification conditional on a convention or something that would amend the Constitution. And some other states tried that as well. The biggest thing that was lacking in the original Constitution for a lot of anti-federalists was a Bill of Rights, right? And so the Federalists were able to say, and here they essentially conceded this point. They said, okay, all right, we should have put in a Bill of Rights. They tried to explain why you shouldn't have a Bill of Rights. In Federalist 84, Hamilton says, you don't need a Bill of Rights because this Constitution has so many limits built into it that starting to specify specific rights and things that the government can't do, you're going to make people think that unless the power is accepted, Congress has it, right? Which is exactly what the 10th Amendment is meant to prevent people from thinking, or the 9th Amendment as well, where it says just because a right is not listed in the Bill of Rights doesn't mean that the states or the people don't have it. But that's essentially the way we've come to think of it in the 20th century. Most people think if there's some contested exercise of power, especially by Congress, look in the Bill of Rights and see if Congress is forbidden from doing that. Otherwise, it can do it. In a way, Hamilton was prophetic in talking about the danger of the Bill of Rights. Hamilton also said, and there are, by the way, some Bill of Rights provisions in the Constitution. There's protection for habeas corpus, there's jury trial in criminal cases, et cetera, et cetera. But the argument failed, basically. And the one point in the debate where the Federalists had to give in was they had to promise that the first thing we'll do is give you a Bill of Rights. But don't call for another convention. Let's start from scratch again. Ratify it, and then post-ratification, we'll give you a Bill of Rights. They didn't have to do that. And in the first Congress, there were a lot of Federalists who said, well, there's no formal promise that was made. We got other more important things to do. And so a Bill of Rights can wait or maybe just be forgotten altogether. James Madison, though, was very conscientious about the sort of implicit promises that had been made in the ratification struggle. He also wanted to end the division of the American people about the Constitution. He thought that a Bill of Rights would win over the former opponents of the Constitution and in some ways make them the greatest defenders of the Constitution if they were defending a Constitution that contained a Bill of Rights. And so you get what we have in the now the first 10 amendments of the Constitution. Although, as I think I mentioned this when I was talking about the 10th Amendment not really being an amendment. Madison made sure that none of the constitutional amendments really changed anything in the nature of the government, right? That when the First Amendment, for instance, forbids Congress from making any law respecting the establishment of religion, they say, well, Congress never had that power in the first place, so you don't need to forbid it from exercising that power, right? In fact, Hamilton said, one of the problems in creating a Bill of Rights is how can you enumerate or specify a right so specifically that legislators won't be able to find a way around it, right? And that's exactly what happens with the free speech and free press parts of Article 1 of the Constitution. Congress shall make no law respecting establishment, nor abridging freedom of speech or freedom of the press. What does it mean to abridge freedom of speech or freedom of the press, right? The First Amendment doesn't say. The common law in England at the time was that it just means no prior restraint, no censorship. You can certainly be punished for damaging things that you say or print after you do that, right? Now, some American states had adopted a more liberal principle, but others hadn't. And sure enough, Congress in 1798 enacted a Sedition Act that punished people after the fact, after publication, for things that they said in opposition to the government. And they did it again in 1918 in the World War I Sedition Act. Right? And though the courts have made it more difficult to prosecute people under Sedition Acts, there's still nothing technically that would prevent the government from enacting a sedition law. Right? In fact, the Alien Enemies Act came up in one of President Trump's recent deportation things. He mentioned that. It's still on the books from 1798. The other ones are lapsed for a time limit. So this question of how effective can a Bill of Rights be? You know, Madison's argument that it's really not changing anything. Congress never had any power to do these things in the first place, with a few minor exceptions, right? Like the Seventh Amendment guarantees you a jury trial in a civil suit where more than $20 is at issue. But come on, right? Or you're not entitled to an indictment by a grand jury if you're accused of a felony. So if a few of them perhaps did change something or haven't been applied yet to the states, but by and large, most people think that the Bill of Rights includes everything that needs to be covered. But another important point about the Bill of Rights is, and this is, I think, the part of the Constitution that people are most familiar with, right? If they know any phrases from the Constitution, they're going to be ones from the Bill of Rights, right? Like the separation of church and state. I know that's not, but people think it's there, right? Unreasonable searches and seizures, things like that, right? The kind of law and order stuff that people really like. They're not going to remember anything from the structural parts of the Constitution. There's a substance in the Bill of Rights that people are much more familiar with. But the idea that the purpose of the Bill of Rights was to protect individual rights, the individual rights of citizens, is all wrong. The Bill of Rights was all about protecting the power of the states, right? It was really all about federalism. The states are saying it's not a question of we don't want people punished for sedition. It's that we, the states, want the power to punish them for sedition. Right? Jefferson's Virginia had a law of seditious libel that was more stringent than the federal standard in 1798. It's not a question of the rights. It's a question of who gets to regulate those rights. Right? It was really about state power, not about individual rights. The Supreme Court changes all that very gradually in the 20th century and then very much all at once in the 1960s. And today, almost all of the Bill of Rights applies to the states, but that's not the way it was at the beginning. This is why if you read the very beginning of the Bill of Rights in the First Amendment, the first words are, Congress shall make no law respecting an establishment of religion. Right? Now, again, there's some argument about whether the fact that the First Amendment begins with Congress shall make no law means that all of the Bill of Rights means only Congress is limited. And it is true that the First Amendment was not the first amendment that was sent out to the states. It was the third, right? The first two weren't ratified right away. One wasn't ratified until 1992. It's the 27th Amendment, and it rattled around for over 200 years. Michigan finally put it over the top. No, Congress can't raise its own salaries without an intervening election, right? So it's not really the First Amendment in terms of what went out. It was the First Amendment among those that got ratified right away. But even more important, the language says Congress shall make no law respecting an establishment of religion, which means that Congress can't make any law in favor of or against a state religious establishment. Right? The New England states, Massachusetts, Connecticut, New Hampshire, still had state establishments. They still had churches that everybody had to pay taxes to support. Most states were going the way of Virginia, which disestablished the Anglican Church. And Jefferson and Madison were the chief architects of disestablishment in those states. But the point was, Congress can't be involved in this at all. The question of whether you want a religious establishment is up to the states, right? And all of the Bill of Rights about the states, cruel and unusual punishment, you can't have that in federal courts, but states are free to have cruel and unusual punishment if they want to. It was all about federalism. And it was meant for really just sort of a guarantee to the states to tell them, entering this new constitution, ratifying this new constitution, you won't be giving up any of your, again, what I refer to as the police power, the general power to legislate for all these matters of everyday rights that people today are more likely to be familiar with. I think it's unfortunate that we've lost sight of the body of the Constitution, the original Bill of Rights Constitution. And if people teach the Constitution at all, they teach the Bill of Rights, part of the Constitution. But that is some of the mostly reflecting changes in the 20th century as the progressives began to transform the Constitution. One thing I'd like to point out in this little, you have the Hillsdale Pocket Constitution, so in the back, all our students take a course in the U.S. Constitution, Politics 101. And we have a reader, an anthology of readings for that. And there's sort of the table of contents for this in the back of the Pocket Constitution. So almost, I think, every one of them is in the public domain and is easily available online. So you can sort of pick and choose what you like from the documents that we pick out for the students in the Constitution course. The vast bulk of it are the Federalist Papers, right? The most important commentary on the Constitution, the one that has become a classic, are the Federalist Papers. But there's a lot of others, especially in the development of the Constitution in the 19th century, the great conflict over slavery, the great controversies that came about as a result of the Industrial Revolution and the urbanization of America, the Civil Rights Movement in the 20th century. Later documents are here in the appendix of the Pocket Constitution.
If you enjoyed this lecture, we encourage you to visit our website, k12.hillsdale.edu, for additional information on upcoming Hoogland Center events and other free resources for educators.